Canada's constitution has this mechanism called the reference power. And so a prime minister can ask the Supreme Court of Canada a hypothetical question about a legal question, and the court can weigh in on that hypothetical. And so the government of the day asked the court, would it be consistent with the charter to extend the definition of marriage to same-sex couples? But the Supreme Court of Canada issued its opinion in this case, and the court was actually very kind of coy in its answer and said, let me see. So I guess like a good example of politicians doing what I just described was how Canada came to adopt same-sex marriage. So this was back in 2005 that Canada broadened the definition of marriage from the traditional definition of a man and a woman to the exclusion of all others. That was the original legal definition. And then in 2005, Canada passed a law defining marriage as, a union between two individuals. So no longer having any kind of designation in the definition of marriage. And so at the time, this is now 20 years ago, the same-sex marriage issue was actually quite divisive in Canada, and not even just divisive in the sense of like liberals versus conservatives. So we had a liberal government at the time, and the issue was actually quite divisive, like within the Liberal Party itself. Again, some of this is like kind of ancient history, but in Canada, Catholics tend to vote Liberal more often, not always, but there's a strong relationship between Catholic voters and the Liberal Party, and there's lots of social science research to back that up. And so the Liberal government at the time, this issue was very divisive within the Liberal caucus itself. And you had a lot of people within the Liberal Party wanting to retain the traditional definition of marriage. And you had people in the Conservative Party who also felt that way as well. But then you also had people within the same party, within the Liberal Party, who thought that Canada should broaden the definition of marriage to include same-sex couples. And so Canada's constitution has this mechanism called the reference power. And so a prime minister can ask the Supreme Court of Canada a hypothetical question about a legal question, and the court can weigh in on that hypothetical. And so the government of the day asked the court, would it be consistent with the charter to extend the definition of marriage to same-sex couples? And so there were four specific questions that were asked in this legal process, but the Supreme Court of Canada issued its opinion in this case, and the court was actually very kind of coy in its answer and said, adding the definition of marriage to include same-sex couples isn't required by the Constitution, but it wouldn't be unconstitutional. So the court didn't actually come out and say the charter requires this, but the way in which the government chose to interpret the court's opinion was to present it as if it had to do this, and as if to say, we've asked the court what it thinks about this issue, and the court has said that the same-sex definition of marriage would be consistent with the charter. And so, the Liberal Party is going to put forward a bill in the Parliament of Canada to make that change. And so that's an example of how, if you didn't have a charter and the courts had no final say, you could have just had a parliamentary process to like hash that out. But it was convenient for the government of the day and for the Liberal Party to have this other institution that it could kind of lean on and kind of subcontract out the difficult question to, and make the question seem like it was a technical legal issue, like rather than just one that was part of politics. And so, so that issue is not controversial anymore because the definition has been changed for these past 20 years. But at the time, this was like front page news. It was covered for a long time. And it was a very big deal.
Right. I think that's such a very, very interesting. You mentioned in passing too, just earlier, you talked about other polarizing issues. You feel like you're walking on eggshells, or you start to self-censor already. You mentioned in passing, I noted here, the Supreme Court's decision on assisted dying. That kind of issue, should it have been actually decided by the court or by elected officials?
So this is a matter that actually was decided in the past by Parliament. And again, there's sort of a long kind of legal saga here. Part of, I think, what would be kind of interesting to your audience to think about is that back in 1995, someone challenged Canada's law banning or prohibiting physician-assisted dying. And this was decided by the Supreme Court, and it was a very divided decision by the Supreme Court. So 5-4. And when you have a 5-4 decision by the Supreme Court, that kind of speaks to how hard the issue is that, these are 9 very educated, kind of eminent people, and they have a very tricky time coming to a kind of clear decision on the issue. But in that 1995 decision, that Parliament has the ability to prohibit this. And we aren't commenting on like whether Parliament ought to ban this, but it's clearly within the powers of Parliament through the criminal law power that it has to ban physician-assisted dying. And then in 2015, the exact same issue, physician-assisted dying, comes up again in a decision called Carter, and the Supreme Court reverses itself and says, actually, we were wrong in 1995, and this is now unconstitutional. And banning physician-assisted dying is inconsistent with the Charter, and the court has kind of creative ways of, it's very reluctant to admit that it's overturning one of its own precedents. What it will say is, well, the kind of values of the society have changed in these intervening years, and these other countries are doing this now too. And so they'll bring to bear polling or social science data to back up their decisions. But that's an issue, and there's lots of other ones that one could point to where it used to be decided by Parliament and now it's being decided by courts. And in some cases, you have decisions where the courts have said, this is not something that we can weigh in on, and then they end up changing their mind because the composition of the bench changes, or maybe they feel like now the public is ready for them to weigh in on that issue. And so again, there are lots of examples that one could point to. So the physician-assisted dying one is one of them, but there's lots of other ones too.
Interesting. That sounds like the court has become a wild card, So you can just pull it off and use it to win the game when it's convenient. Let me add to that. Your critics would say it's either the courts have the power to make decisions or not. And why the hell in the first place do we have them if they can't make decisions? How would you respond to that?
I think that the courts, and the Supreme Court especially, like I said, the powers that it has, some of it, not all of it, but some of it is the product of, a democratic and political process. There's a Supreme Court justice who's now deceased, named Bertha Wilson. She was the first woman ever appointed to the Supreme Court of Canada. And she wrote an article once called "We Didn't Volunteer." And the title being as in, like, the democracy chose to add a charter and now we're just doing our job as required under the Constitution. So like, we didn't choose this. We didn't volunteer to become the institution with the final say. And so I appreciate that and take that point. But there are lots of other things that the court has done where it has been more kind of adventurous or creative and has really stretched the meaning of the text of the Constitution in ways that I think would make the people who drafted the charter would be very surprised in kind of where we've ended up. And I don't think that the role of the courts is going to change anytime soon necessarily. And I imagine that the court is going to keep making lots of headlines for lots of time going forward too.